It is August 21st of 2026, and this is the Court Gallery. We kick things off with Judge Buckley handling a messy civil dispute over an illegal sump pump connection. Will the contractor be held liable, or is the homeowner just out of luck? Next, before Judge Webster in Kansas, a defendant begs for a fourth last chance at probation, claiming his sister's maid service will keep him out of trouble this time. Later, Judge Elmore deals with a defendant whose positive drug test threatens his bond release, as usual. Finally, Judge Middleton makes a special appearance and is absolutely flabbergasted by a remarkably lenient original sentence for a habitual offender. Buckle up, ladies and gentlemen. All that and more starts right now.
Mr. Wilson, Mr. Robbins, both raise your right hands, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, I do.
Yes, sir.
All right, and Mr. Wilson, you're seeking $7,325.32 for effective drainage work.
That's correct.
Am I correct?
Yes.
Is that
Sorry, go ahead.
okay? I mean, that's the nature of the claim. Is that correct?
Yes, that's correct. I can give more details if it's
Okay.
helpful.
All right, go ahead. Explain to me.
Yes. So, Your Honor, my basement sump pump discharges groundwater into the sanitary sewer. Dan Barabo, who's a licensed plumber, inspected it and swore under penalty of perjury, which is my Exhibit Q, page 76, that the discharge piping is connected to the sanitary sewer line, that the connection is, his words, visible and unambiguous, and that discharging groundwater into a sanitary sewer is not allowed under applicable plumbing codes and municipal regulations. Robbins is the company that designed and installed the collection system and sump in 2018 for the previous owner, the person I bought the house from. That previous owner made the final connection. I have never said that Robbins made that. Then, in December 2020, Robbins contracted with me to expand that same system and plumb the new work into what was already there. The contract Robbins wrote promises on its face that, quote, all work to be completed in a skillful manner according to standard practices. That's my Exhibit D. Adding more drainage to a system whose pump discharges groundwater into the sanitary sewer is not skillful work according to standard practices. Robbins' own 2018 proposal materials label that line sewer line. Robbins said nothing to me about where the system discharged. They took the money and enlarged it. The drawing that came with Robbins' proposal is Robbins' own file. The properties show the author, Lee, that's Robbins' sales representative, Lee Mattingly, created it in Microsoft Word, December 13th, 2018. That's Exhibit C1, page 17. Whatever its origin, Robbins made that file and sent it out with their proposal. And on that drawing, the only drain line shown is labeled sewer line. That's Exhibit C, page 16. And I can tell the court from living in that house, there is no drain line in that basement that isn't the sewer. There was nowhere else for that pump to go. Page 2 of my contract says Robbins will complete all work called for in a professional and workmanlike manner according to standard practices. And there are just two short points beyond that, Your Honor. Number one, Robbins' own filing tells the court what Robbins' standard practice is. Page 4, Robbins does this work, but when it does, it never discharges groundwater into a sanitary sewer. That's their standard, their words. My contract required work according to standard practices. Enlarging a system that discharges groundwater into the sanitary sewer and saying nothing to me about it is not that. And finally, the contract Robbins wrote for the previous owner in 2018 contains this sentence. Robbins & Co. is not responsible for the function of the existing system that contractor slash homeowner will be tying into. That exact sentence is not in my 2020 contract. Robbins drafted that protection for itself when it wanted it. The plumber quoted $4,125 to correct the piping. Mr. Barbo's bid says sheetrock removal is necessary and that putting it back is not included. A separate contractor, Manny's Unique Remodeling, quoted $3,200 to patch and finish the areas the plumber opens. Robbins filed no competing repair estimate.
All right, thank you. And Mr. Robbins,
Yes, sir.
go ahead.
So, I'm not sure where to start, but basically he's correct in the sense that, somebody, I think the previous owner, he said connects this to sewer. So, we didn't do the work, we didn't bid for the work. And so, he's asking us to pay for work that we never were even asked to do, or bid or do. And so, we've been communicating, and every time that I've communicated with Mr. Wilson, I've asked, can we come take a look at what's going on? Because this stuff was done in 2018. And so, but he's denied me any attempt to even take a look at it or see what's going on. As a matter of fact, the information in this case with the that he's provided is the first time I've even seen these documents. So we didn't, I think he admits we didn't do that work, but he's asking us to pay for it to be replaced and redone. And I don't have no basis for validating anything other than, we didn't do the work he's asking us to repair.
Okay, so I think Mr. Wilson's theory is that when you did do work in the basement on the plumbing in 2020, is that right, or early 2021?
We in 2020 we did an extension. I think I submitted a drawing to the court where we were asked to extend the pickup area in the floor, 20 something feet away from this area we're talking about. It was just extending the input in the floor. We'd take up the concrete and just extend the drain 10 feet and put the concrete back.
Right, and at the time that you did that, knowing from the prior occasion in 2018 that the pump had been connected to the sewer line by the homeowner, did you raise issues with Mr. Wilson that it wasn't smart to add load to that?
Oh, we didn't see that there. But at the time we did the work, we were just extending the input area of it. Only the downstream stuff we didn't have any involvement in. So I really can't comment on whether it was hooked to sewer, not hooked to sewer, who did it, or anything at that point.
Okay. So if I remember from reading your materials, that the main point you had made was that the homeowner said they would deal with the connection for the pump that you had installed. Were you aware what they were connecting it to?
No, that was at the time we were working for Moxie Creek, and our proposal was just to install a partial system. So we didn't have any involvement of anything beyond that.
And so what was your thought as to where they were going to install it? Where were they going to connect your system to?
Well, I don't, since it was 2018, I don't know, it's a long time going back, but typically we will install it to a downspout drain or something like that. We don't do plumbing, and so we don't have any involvement of that. So and it was and I think at the time the building was under construction because Moxie Creek was remodeling everything. They were a contractor on site and they were redoing everything. And he had his own people.
So what did you install in 2018?
We installed in the ground, a footing drain along the footing, and then a catch basin, and then a pump.
Okay. And when you're installing a sump pump, what's the standard practice as to where the sump pump drains?
If what we recommend is that it be drained to like a downspout drain, or an outside it could go to a mold or a flow system, a flow tank system. Outside somewhere where it would flow away from the house is kind of what we recommend them doing.
All right. Okay, so when you are installing sump pumps, do you believe it's any of your responsibility to see what it's connected to, or do you just leave then the owner of the property to decide how to make that connection?
Normally, when we're talking with customers, and what we try to do is give them a complete system where we're running the whole system and it's working. But when we're working with contractors in this particular case, they tell us what they wanted, what they want us to do, or what they want us to where they want to end the project to save money, and they could do that themselves. And I think at the time, in 2018, this was under remodeling, and so the Moxie Creek, the person we were working for, was they had said, just put in the system and the pump will take it from there. And it's common. We see that quite often when it's these kind of systems, because they decide where they want to put it. They're in the middle of construction, and they take it from there. And we do put in our contract, that specific wording that, that homeowners to connect it, and we're not responsible for it downstream, because we want to make sure it's clear that, we're not doing that work, and we don't charge for it. We don't bid it. We don't put it in there specifically.
Okay. And when you came back in 2020, I think one of Mr. Wilson's arguments is it should have been obvious to you that it was connected to the sewer line, and inappropriately so. What are your thoughts on that?
The crews that go out and install the drain systems, that's what they do. They install drain systems. And so they're, these floor drain systems, laborers, and it's just like on the pickup side of everything. So they're not, they don't go through and inspect people's homes and determine these things. They don't know. It's hard to tell, what they're doing. If it's our system, we know because we know what we've done. But beyond that, we don't have any idea of what they did. I can't tell you if it was done right or done wrong. I'm not really in a position to make that judgment. I didn't do that work. I don't know if they got a permit. I don't know who did it. I don't know the quality of it. So it's awful hard for us to form an opinion on something that somebody else did, other than, assume that, that it's done correctly, but, we just don't have we're just not plumbers. We don't plumb stuff to sewer. We don't do that work.
Right. So when you come back in 2020, is there any way that it should have been physically obvious to you that the line wasn't to a downspout drain or some outside process that moves the water away from the house, as opposed to the sewage line?
Not really. I mean, we can't, like I said, it's our our guys if it's, though our guys don't deal with that. So we would have to take and investigate it and bring, and look at where it's going and determine who did it. It's other people's work, so we don't assume it's wrong. It's other people's work. So it's like if you're replacing a window, we don't judge whether the window was done correctly or not if we didn't do the work. So we wouldn't know. And our guys really they're not plumbers. And so they do they're drain guys, so they don't understand that kind of stuff. They're not, in a position to make a decision that way.
Okay, but they understand they don't connect groundwater to sewage line?
Well, we don't connect anything to the groundwater to sewage line. All of our stuff is pumped outside into a downspout line. That's how we do it.
Can I add anything, Your Honor?
Yeah, I'll get back to you in a moment, Mr. Wilson. I'm just sorting through what I'm hearing here. All right, so Mr. Robinson, 2018, the initial installation of the pump, did Moxie indicate to you at all how they were going to connect the pump, or you just said they said we'll do it and you ended with that? Okay, it's up to you. We're not going to take responsibility for anything downstream of the work you do.
Yeah, the way it goes with this particular, like when you work with a contractor like this, is they ask us for a quote for doing certain work, and we provide the quote. If the quote's not complete, we'll put in there. Generally, we'll say we'll pipe it to the downspout. The pipe. We'll tell it what it is and what we're doing and define the scope of work. When Moxie Creek asks us to do just put the system in the pump, we'll take it from there. Then we put a disclaimer in there to make sure people understand that we're not doing that work. And at the time, I believe that, like I said, it looks like this house was being remodeled, and so we had no idea what they were going to pump, connect it to, and I at the time, and even now, I don't know, it. This is the first I've ever seen a picture that's connected to what appears to be the sewer. Mr. Wilson's had someone come take a look at it, and so it sounds like it's connected to sewer. And so I've never seen it. He's never let me come to the house and look at stuff to try to fix it or try to figure out a plan, But so we just don't know what they're doing. We're not putting in a complete system. We're asked to put in, a part of a system, and they'll take it from there, and then that's where we leave it. So we don't go back and determine, if what they've done beyond our system is correct, or if they got a permit or nothing. So we just don't. It's turned over to them at that point and just do what they ask us to do. And we price it and we did it appropriately.
All right, thank you. And Mr. Wilson, how come Moxie Creek isn't a defendant in this case?
Robbins is the party that designed the system, installed the system in 2018. They did not make the final connection, but Robbins came out, and under the 2020 contract with me, I paid them $3,000 something to expand that system. And what I have now is an expansion of a system that cannot operate legally. And I believe that what I paid for is workmanlike performance. And in order to have a functioning, a lawfully functioning system, that needs to be rerouted to an appropriate place.
Okay, so it's your position that when Robbins came back out in 2020, they should have ascertained where the water from the sump pump was going, where the connection was. Is that your theory?
Absolutely. And Robbins has also maintained my sump on multiple occasions. They, I certainly believe that when they were out extending that system, that it would have involved knowing what it connects to and testing it, and that it was conspicuous. And the sump is literally, I mean, you've probably seen the picture in the exhibits. It's literally 2 feet from the sewer line, and it's right there. It's visible. It's impossible to miss if you know what a sewer line is. I did not. And I think the other key question here, if Robbins had never come out for that 2020 contract and never installed those extra 10 feet of drainage to expand the system, would I still be paying a plumber to reroute this discharge? And I think the answer is probably yeah, about the same. And I want to be straight with the court about that. I've never said Robbins created that final connection. What I say is that Robbins promised to do my 2020 work skillfully according to standard practices. Robbins' filing tells you what that practice is. Robbins enlarged a system that does exactly what I said. It puts more groundwater into the sanitary sewer. They took my money. They said nothing to me. That's the promise I paid for and that I didn't get. And the 10 feet I paid for can't lawfully operate until that discharge is rerouted. And so the reroute is the cost of finishing what I bought.
Okay. All right.
And as for the question of why I did not let them come out to look at it, I will add that it is true that in March I told them a site visit to document the configuration was not a remedy. That's in my packet. What Robbins' filing left out is what happened next. On March 21st, I wrote that I would allow a site visit, provided Robbins committed in writing before the visit that if the sewer connection was confirmed on site, that Robbins would cover the remediation. On March 25th, Robbins wrote back, in their words, saying they're not able to assume financial responsibility prior to verifying the existing system configuration, and they repeated their offer to come, quote, review and document the system. So access was available on that condition. And in addition, Robbins' own documentation says that they would not even be able to repair the sump pump knowing it was connected to the sewer because they're not a licensed plumber. And at that point, I already had a signed statement from a plumber saying that this was connected to the sewer. And so I don't even know what Robbins could have remedied given their licensing.
So your exhibit I is the photo of the pump connected to the sewer line. Is that right?
Yes, that's right. That's the exhibit. That black PVC pipe that connects the
Right.
sump to the sewer is presumably what the prior owner installed.
Okay. All right. So Mr. Robbins, looking at that photo, what's your thought as to whether your folks who went out in 2020 or its subsequent maintenance of the systems should have noticed that the connection from the pump was to the sewer line?
I think the guys that do the work we're talking about doing, they would look at that and they wouldn't have an opinion whether it was right or wrong. They're just not qualified. I look at it and it looks to me like it's a different pipe. It's black pipe, and it's not our pipe. Our pipe's white pipe. And so they would they would look at it and they would say that somebody else did that work. It's not our work, and they wouldn't now if you know, so they just wouldn't know, you know, but if Mr. Wilson knew that before, if he actually knew that it was connected to sewer for sure, then I would have been nice for him to tell us before we went out and did a service call.
Okay.
Yeah, that's
So when you look at it, I'm inferring from how I'm hearing you say this. When you look at it, you say, oh yeah, that's connected to the sewer line, and that's not what we would have done. So you recognize that as being connected to the sewer line, is that right?
Well, I can't say that for sure because really, when you go out there and look at these things, there's you got to look at all kinds of stuff. You got to look at, because customers do different stuff. Contractors and other people do different things, and so you can't just make an assumption on it. And so, what I would do probably is, what would have been nice to do is go out there and take a look at it. I can confirm whether it is or isn't. Look at maybe the sewer card, find out that's where the sewer is located. Look at where these lines go. But in some cities, they do allow that. So it's not like it's not allowed. It's just it's by sewer district. I know that they allow different connections that way, and that's generally what a plumber would do. And so we don't know that they find out what the sewer districts will allow and what they won't allow, and then they do whatever they do if that's what they're going to connect to. So it's not uncommon. I mean, we'll see pipes connected like if they're grandfathered in, to connect years ago. That's all. They always ran that systems into the sewer. Matter of fact, they still run floor drains into the sewer. All kinds of things go into the sewer. So it's not uncommon to see something like that. It would be it was really, I mean, even if I had seen it, if I would just look at it and go, well, they got a permit, the contractor installed it. I would assume it's correct. I wouldn't assume it's not. But like I said, it was just Mr. Wilson's comments a little bit ago that he knew that it was sewer and because he had a guy come take a look at it and that was a plumber, and it would have been nice to know that because I believe he said he had us come out before we did the service call on the pump.
May I share how I learned about the illegal
Okay,
connection?
I'll get back to you, Mr. Wilson.
Okay, thank you.
Yeah, go ahead, Mr. Robbins.
Yeah, I mean, if he told us that it was sewer, then we would say, well, is that okay? I mean, did you check with somebody to make sure that's okay? I mean, those are questions that you would ask, and but like I said, I still don't know. I mean, I'm looking at it, and I guess if I go by his documents he provided from the plumber that says it's hooked to sewer, then I guess it is. Whether it's legal or not. You know, yeah, I don't know. I mean, we're getting kind of outside of what we do here.
All right, and then the 2018 diagram where the only apparent drainage line is listed as sewer line. What are your thoughts on that?
On the 2018?
Yeah, on 2018.
Yeah, that generally when we go out there with the service guy or the guy that's actually looking at doing the work, we try to mark all the locates. He marked that line and as that, and Mr. Wilson called us and asked us for our documents, and we pulled them all and sent them right to him. That's what we gave him those documents. What we're looking for is when we're excavating, putting in the sump pumps, and we're digging in the footing drains, that we don't, if we see anything that is that's going to be in the way, they mark it on the drawings, and so that's what that is. It's a typical thing. That was what the guy in the field marked it as.
Okay. So your position is you marked the sewer line so that you all would know where the sewer line was. You didn't know. It wasn't an indicator that the sump pump was being connected to the sewer line.
Yeah, and I don't, when he marks it, it's basically, and I'm looking at the drawing, it looks to me like there was a connection at the floor. So I don't know what he's seen out there in 2018, because like I said, this was remodeled. Like the drywall and all the trim is on top of our catch basin, so that was all installed after the fact. And so he probably just marked it and then labeled it that way, whether he knew it or not, or whether Moxie told him it was or not. We're looking for more like, don't hit stuff when you're digging, try to find, if we know something's in the floor like that, don't hit it, we have to excavate all this stuff out.
Okay. All right, Mr. Wilson.
Yeah, so one clarification on timeline. And also, Mr. Robbins mentioned in his brief that I'm an architect, and I'm actually not an architect. I'm a software guy. I know nothing about sump pumps and sewer lines. And so in 2025, I knew nothing was wrong until later in the year when I had 3 contractors come out, including Robbins, to quote a completely separate project in my crawl space. And they all came out, they did their quotes. One of them, not Robbins, proactively pointed out to me, hey, you've got a sump pump connected to the sewer. That's a code violation. And then the second one, I confirmed with them, like, yes, that's not how you do it. And then Robbins didn't even notice because they were the first contractor to come out. That's when I learned about it and started having a very long email exchange with Mark's office staff, where they would not take responsibility for it. And that's when I reached out to a plumber to come out. I think it was early 2026 to verify the situation and quote what it would take to rectify.
Okay, and to be clear, the damage you're talking about is the fact that it's not to code. You haven't had spill off or anything like that that's led to structural damage in the house. It's just that it's not to code, and you need, in order to bring it to code, you've incurred certain costs.
Yeah, so if I were to sell this house, this would come up in the inspection. It would be something I'd have to rectify. And I'd have to pass this. First of all, I have liability. If sewer water if the sump is pumping water into the sewer and something happens to a neighbor's house or something, the city can come after me. I'm not waiting around for that to happen. I want to get this taken care of, certainly before I ever sell the house and have to deal with inspections and this coming up there. But this is a liability for me today. I have not received a citation from the city yet, but I'm trying to get in front of it.
Okay. And Mr. Robbins, I think you've said it a number of times, you say we're not plumbers. So when you do the work that you do, in this case, for example, do you have an obligation to be familiar with the Uniform Plumbing Code?
Oh, none of our components hook to the plumbing, and so we don't. The plumbing code is, plumbers, so we'd bring plumbers in if we were doing plumbing. I mean, like, I guess I'm using it a little bit loose in the sense that, there's plumbing is, when you're doing plumbing in a house, you do sanitary sewer, you do wastewater, that kind of thing. And that's what plumber is. When what we do is when we're doing it, we're not connecting to any of that. We're just taking our PVC and coming off the drain pipe and running it right outside to a downspout drain line.
Okay, so when your folks come out 2020 and to add on to the system, they see the black pipe there, and it doesn't, they're not in a position, I think you're telling me, because you're not plumbers and you're not worried about the Uniform Plumbing Code because that's not your job. They're just saying, okay, they want more footage coming into the pump, so we'll do that, and that's all we're going to deal with, and we're not particularly concerned that there's this pipe going into a bigger pipe, which turns out to be the sewer line.
I think if we know, like if when we come out there and do that drainage, and if we knew that it was that we knew the guy that's doing the bid out there, if he knows like something like we would give him a bid. If it's like, oh, that's wrong, like Mr. Wilson said, then we would say that's wrong. If we knew that, we would have told him. We would have said that's wrong. It needs to be fixed. It shouldn't be done that way. It should be done this way. But we didn't know. I mean, we didn't. Our guys just don't. Didn't know that at the time. And so
okay, let's boil it down to that question, because looking at the photo, it's pretty clear there's a You know, there's black PVC going from what is the sump pump into what Mr. Wilson asserts is pretty obviously the sewer line. You know, sort of looks that way. It's not, I don't see any writing on it saying sewer line, but that's what it is. So is it reasonable for your folks not to notice that there was a piping going from the pump to that big line?
It's common to see this kind of stuff, and so they weren't looking at, you know, what some other contractor did or what other work that contractor did. And so they're just focused on what they were asked to do. They were asked at the bid to extend the drain system because there was more water apparently that needed to be captured at the on the floor of the home. And so we just bid that portion. I guess like I said, the guys are bidding what the customer asks us to do, and we don't immediately assume what was done. This pipe was wrong. I mean, we don't go in and do that. I mean, if we knew that it was, if we knew what it was, we would tell the customer and say, you know, do you want a bid to fix that? You know, but we didn't know.
Okay. All right. And Mr. Wilson, when did you become aware that that connection was to the sanitary sewer line?
It was, well, so I couldn't tell you exactly the answer to that because I first of all, didn't know that connecting to the sewer line was even a bad thing. But I learned that it was a problem in late 2025 when I had these other contractors, including Robbins, come out and they pointed out that this is a massive code violation, not just the plumbing code, but also the Olympia municipal code as well has a similar thing about connecting drain water or groundwater drainage to the sewer system. That's when I learned that it was a problem, and that's when I brought it to Robbins' attention via email.
Okay.
And I'll also add that the scope in 2020 specifically said that they're installing 10 feet and plumbing to the existing multi-flow drainage system. It wasn't just adding 10 feet, it was connecting it to an existing drainage system. It's all part of the same system that connects to the sewer.
Right. So, Mr. Wilson, the damages are that you list here, which I think are, you know, accurate to what you're seeking. The quote to disconnect the sump pump from the sewer, reroute the discharge, and then to repair and refinish the drywall. It seems to me you would have had to do that regardless of 2020, 2025, because the work had been done by Moxie Creek, which set that up. So at the point you discover it, let's take Robbins out of it entirely. Say they didn't show up in 2020 and 2025, you still would have those costs, right? And you would have to seek it from Moxie Creek or from the prior owner.
That's true, Your Honor, though I also would not have paid for the 2020 work from Robbins and Co., which was $3,000 something. So at the very least, that, you know, if Robbins had never been in the picture for that work, I would not have incurred that cost. But given that I did incur that cost and they did work that was supposed to be performant, the cost, the damages I'm asking for are the number to make the system functional and lawfully functional that they sold me in 2020.
All right, thank you. And Mr. Wilson, what was the cost of serving the claim on Robbins and Company?
The cost. So the claim service cost was $85.
Thank you. Mr. Robbins,
Pardon me?
did you have something else you wanted to add?
Oh, I did. Mr. Wilson mentioned that he wouldn't have had the cost of the work in 2020. The cost of the work in the 2020 was there was other water leaking in the basement, and so that system, that 10 feet extension, picked up that water, and so it did solve a solution. It did fix it did fix. He would still have a leak in the basement if we hadn't installed that extra 10 feet of drainage system in his basement.
Right. Yeah, I understand that. Okay, so interesting case. Involves a number of interesting legal issues here. Robbins and Company installed the sump pump. The contractor at the time said, we'll take care of the connection. And Robbins wrote into their contract that they had no liability for the connection being made by Moxie Creek. So that's pretty good legal protection. And I think is recognized once that connection's made, the work to reform the connection to bring it into compliance with plumbing code and the municipal code are costs that Mr. Wilson would incur as the new homeowner or relatively new homeowner, regardless of whether Robbins and Company got involved in this case. So I don't think those are the appropriate damages. The fact that Robbins came out and did work in 2020 to address increasing the access to drainage in the basement for Mr. Wilson, in my opinion, should not have been done without Mr. Wilson's permission after relating to Mr. Wilson that it appears the pump was connected to the sewage line and it would be inappropriate to add water to that line when it's already inappropriately connected. So I think at that point, even though Robbins provided benefit to Mr. Wilson by adding 10 feet of line, the people doing it, in my opinion, looking at the photo, it should have been really obvious that the setup that Moxie Creek had put together was something that wasn't compliant with both the municipal code and the plumber's code. So I will grant Mr. Wilson judgment in the amount of the bill he paid for the work in 2020, that even though it provided benefit to him, should not have been done. And so that is in principle $3,832.52 plus filing fee and cost. So it brings the total judgment for Mr. Wilson to $3,957.52. And you're muted, Mr. Wilson.
Your Honor, Exhibit G has the 2020 invoice, which includes tax as well. The total that I paid was $4,192.78 in total.
All right, with that correction, total judgment is $4,327.78. All right, the judgment would be available to both of you in the civil file with the court. Thank you,
Your Honor.
All right, we are on the record in the 13th Judicial District, District Court, Greenwood County, Kansas. This matter comes on for show cause hearings in GW 2025 CR 204 and GW 25 CR 206, each captioned State versus Tyler Marshall Similar. And then we have GW 26 CR 26. Is that also for show cause or is that for a status? I've got it down for show cause.
That's the status, Your Honor.
That's what I thought. Okay. So how do you folks want to proceed? Do you want to address the status first, or do you want to go with the show cause? I do notice probation officer Jessica Morgan is present. Any preference?
Well, Judge, we have a stipulation on the two show cause cases, and then on the status, we'll be picking up a plea today.
All right. Let's see. How does your client wish to proceed then today on these hearings, Mr. McClendon?
Yes, Judge. On the 26 CR 26 case, Mr. Similar would plead no contest to count one. That's violation of protection order.
All right. Well, let's just jump into that then. Mr. Similar, we're going to be on the record, particularly in all your cases, but at this time we're going to address Greenwood or GW 2026 CR 26. And as your attorney said, in that case, you're charged with one count of violation of a protection order concerning conditions of pretrial. And that particular charge that was filed on February 11 of 2026 alleges that on or about the 9th day of December 2025 in Greenwood County, Kansas, you, Tyler M. Simler, did contrary to the statutes of the state of Kansas, unlawfully and knowingly violate conditions of your bond or pretrial release in Greenwood County 2025 CR 204, which ordered you not to have any further form of contact with any witnesses or victims in that matter, to wit, Savannah Heights. And they're alleging that you had contact with Savannah Heights December 9th, 2025 in violation of your bond or pretrial release in 25 CR 204. How do you plead to that today, sir?
No contest, Your Honor.
By pleading no contest, you're not admitting the charge, but you don't want to deny it and take it to trial?
Yes, Your Honor.
And you understand that even though you're not admitting the charge, you still may very well be found guilty of it? Based on your plea?
Yes, Your Honor.
Is anyone making you enter this plea today by any threats or promises other than maybe a plea agreement concerning the other cases?
No, Your Honor.
You understand that if I accept this plea, you will have given up your right to trial, and if you are found guilty, you will be unable to appeal your conviction?
Yes, Your Honor.
All right. Ms. Gillette, I find the defendant is knowingly and voluntarily entering this no contest plea. Have you a factual basis to support it?
Yes, Your Honor, we do. On December 9th of 2025, there were jail calls that were being reviewed for an unrelated case. There was a recording between Mr. Simler and Ms. Height. They use, all their names and stuff. And she answered the call knowing that he said that was his name. The call occurred on 11/21/2025 at 11:09 hours from the jail. It went out for Gordon's account so that it was they tried to hide it through Mr. Gordon's account.
And he was another inmate at the time?
Yes. And they had a no contact order in these other cases, and he called her from the jail phone on a recorded line.
And as you said that she was made known of who the call was coming from. Is that through that standard recording from, this is a call from an inmate at the Greenwood County Jail lingo? And
Yeah.
they would have named Tyler Marshall Simler? Okay. All right, I find the state has provided an adequate factual basis to support this charge and this no contest plea, knowing that the Greenwood County Jail is in Eureka, Greenwood County, Kansas. I do have jurisdiction and I find the defendant guilty. Are there any recommendations for sentencing from the state, Ms. Gillette?
Your Honor, our recommendation is going to be 12 months underlying suspended for 12 months of probation. The standard cost of court cost, probation fee, booking fee. I'm not asking for any fine, and the court to determine if there should be any attorney's fees for Mr. McClendon's services, and that he would meet with probation today. And then I think we still have his other cases, so that's it on this one.
Yeah, we may want to hold off on disposition, but Mr. McClendon, is that your agreement for sentencing recommendations?
Yes, Your Honor.
All right. Okay, so Mr. Simler, I'm finding you guilty, but before I impose your sentence, I want to see how probation, how that turns out in those other two cases, 25 CR 204 and 25 CR 206. It certainly appears that you violated the law since you went on probation, as evidenced by your conviction in this matter. So how does he want to proceed on those two probation warrants to show cause, Mr. McClendon? Does he want a hearing?
Judge, we'd stipulate to the motions on file. And
All right.
essentially, I think they agree.
He's
Say again, Your
waiving.
Honor.
You said he's stipulating. Does that mean he's waiving hearing too?
Yes, Your Honor.
Okay. All right. So, Mr. Simler, in these other two cases, GW 2025 CR 204, looks like you were convicted of unlawful possession of a controlled substance, a Class A non-person misdemeanor. You were put on probation with Jessica Morgan, who's here to, I presume, testify to the allegations and a request to revoke you. That is, that you failed to pay court costs as directed, failed to pay fines as directed. That when she filed this on April 2nd, 2026, you had made no payments to date with the balance of $263. She also alleged at that time that you had failed to report to her as required, that you had not made any contact with her since you went on probation. And that would have been February 24th of 26. And as of this filing, April 2nd, you'd not had any contact with her. She alleges she tried to contact your phone numbers that she found in the court's recording system without success. She alleges that on March 13th of 26, she sent out a probation violation letter to the email on file with a reporting date telling you to report March 23rd of 26, but you did not do so. So she pretty much just decided you weren't going to be a good probation candidate and requested probation. Now let's look at the other case. That is 25 CR 206. Well, that was, yes, the first one I just mentioned was 25 CR 204. Then you're also here on a warrant to show cause why your probation should not be revoked. In 25 CR 206, for which you'd been convicted of interference with law enforcement officer, a Class A non-person misdemeanor. And Ms. Morgan on April 2nd filed a motion alleging that you'd failed to pay your court costs in this case and your fines in this case as ordered, that you'd made no payments to date with a balance of $263, and that you'd failed to report, and pretty much the same position with both cases. You were given 2 probations, and according to your probation officer, you never showed up. You never made payments as ordered. And now I'm finding that you've committed a new crime, and I know that's standard condition that you don't do that. You do have the right, Mr. Simler, to deny these allegations and to have a hearing in which the state can either prove you violated or they can't. If you haven't violated, the motions for revocation would be denied. If the evidence convinces me that you did violate, then I could revoke your probation and have you serve the mandatory sentence. I could reinstate your probation after giving you a sanction and order you to probation again. I could give you credit for time served and dismiss the case. Any of those are options. But certainly the first consideration would be whether your probation should be dismissed and you should serve the remainder of your sentence in these cases. So at this time, Mr. McClendon, you said he does stipulate. Is that right, Mr. Simler? You stipulate or agree that you violated and give up your right to a hearing? Or do you want a hearing? A trial, basically, on the facts that you violated.
I am agreeing with my attorney, Your Honor.
Okay, so you're not wanting an evidentiary hearing today for the state to prove you violated?
No, Your Honor.
Or to attempt to prove. They may not be successful. Are you stipulating, that is, agreeing that Ms. Morgan's statements about violations are true? Or do you want to deny those? That
yes,
you
Your Honor.
failed to report and that you failed to pay. Do you want to admit those or deny them and make her testify?
I admit them, Your Honor.
All right. Is anyone making you give up your right to this hearing or making you stipulate, that is, agree that you violated?
No, Your Honor.
All right. And you understand you can challenge them and have a hearing?
Yes, Your Honor.
All right. Well, I find that you're knowingly and voluntarily waiving your right to hearing and stipulating to the violations after conversation with your attorney. Accordingly, I do find you in violation of your probation on both 25 CR 204 and 25 CR 206. For disposition, are there any recommendations, starting with the state?
Your Honor, he has been in custody 31 days. My recommendation is that he have a 31-day sanction. Give him credit for the last 31 days he's been in custody. Reinstate a new 12-month term of probation that goes along with today's plea and the new case. And that he have a meeting with Jessica Morgan today before he gets out of the jail, and that he meet with her to get his probation started.
Mr. McClendon, your recommendations for disposition?
Judge, I join in the state's recommendations.
Well, Mr. McClendon, you were given probation not once, but twice, and you ignored it. You just ignored it. Then you went out and you got this new conviction today, new charge. And everybody says, give you credit for the 31 days you served on the new case. During the time apparently you couldn't make bond, and put you back on probation. What in the world would be different? Why would you not just ignore the third probation?
Your Honor, because this time I'm guaranteed to have a job when I get out. My sister said as long as I get this stuff taken care of, I have a job with her. She just bought a business. If you give me one more chance, I will get this probation completely done and taken care of. And I want to just get my life back on track, Your Honor. Honestly, the things that I've went through those last 30 days and being in jail for 30 days have shown me that I don't want to be in jail. I'm not a person that's meant to be in jail, and I'm going to do what it takes to get this done correctly. So I'm hoping for this one last chance, Your Honor.
Well, so far you haven't given me any reason that I haven't heard, I don't know how many times, countless times. It's what everyone tends to say, and I was hoping you could give me something unique to your situation.
Your Honor, if I may, the situation that I was in when you gave me probation to start with, I was stuck in Sedgwick County homeless. Now I'm not anymore. Like I said, I have a plan to get back on my feet finally, and I actually have family help this time. And I'm hoping that if you do give me this chance, maybe I can show you that not everybody's the same, that I actually truly want to do better and be better and actually get this taken care of properly.
Well, I know that everyone's not the same, and I do look at each person individually. I'm certainly looking at you as an individual, even though you told me the same thing I've heard countless times. And I suspect that when people tell me that, they probably mean it. But then when they get their freedom, their thoughts change. Their goals change, or they think they can get away with things. I don't know. I'm just looking at you here, that you've had one strike on probation. Probation is usually a one-time, okay, you screwed up, let's give you another chance. And you had
Right,
that
Your
chance.
Honor. And
then you screwed up again with a new case, and you were given another chance. And now here we are. You didn't even report.
Your Honor, if I get another chance, I do have kids, and I've been trying to get my life back together because I want to have them in my life, and I finally just started getting them back in my life right before I came in. That's why another reason I'm trying to take care of these is so that way I can have my kids back in my life. And if you put me back on probation with this one last chance, Your Honor, I'm not going to mess it up because I have 4 kids and I really want to be in their lives and be a good role model for them.
Why wasn't that true, the first probation or the second probation?
Your Honor, I didn't know that I had a chance for the second time. I only knew about the first time because I didn't have a way for contacting or anything. And this time it's different. This time I'll be able to contact. I have the ability to make it to probation, and I have no problem with starting probation before I leave jail.
Well, they usually say 3 strikes and you're out. This is your third time to request probation. You didn't report. You did not even report the first time or the second time. I'm real accommodating. If you can't pay, just show me a little good faith effort. You paid 0 on either one of these cases, nothing. You were given the benefit of I think your fines may have been, well, I guess you did have a little bit of fine. But in any event, you didn't pay anything. You didn't report. If you can't even report, there's no point in probation.
Well, I can report now, Your Honor. That's what I'm saying. Now that I have a foundation and I have support in my life now, and I have a way to get this all taken care of, that's what I really want to do. I want to prove to you guys that I can do this. I just want one more chance to do that, Your Honor. And with this one more chance, I will prove to Miss Gillette and Miss Morgan and Mr. McClendon that I will get my probation taken care of.
And the only thing that would be different is your sister would give you a house and a job, right?
Yes, Your Honor. And she's going to make sure that the only way that she told me that I'm allowed to get the job and everything is to be reporting to probation. She's going to make sure that I get reporting. She's never been in trouble with the law, and she really wants to see me do better in my life. And I would not let my sister down because she's the only one I have left that's willing to help me with anything. She's the only one that I've had left or even had that's finally willing to help me, Your Honor.
Didn't you let her down the first 2 times?
No, Your Honor. She wasn't part of it the first 2 times.
Well, it sounds to me like your probation plan would be to have your sister basically do your probation. She's going to make you get out of bed of a morning. She's going to make you go to work. She may or may not succeed in making you physically do the work she needs done.
No, Your Honor, that's not the case at all. She's not like that. She's going to make me do it all by myself. The only thing she's helping me with is making sure that I make it here. And it's not always going to be her that makes sure I make it here. When she has work, because she owns 2 different businesses, I have to ask my mom to bring me. So it's not that just all on her. I have to make sure that I have rides to get up here as well, which I've already talked to my family that's willing to help me, and they're all willing to make sure that I don't miss probation. But the only way they're willing to do it is that I get in contact with them ahead of time because they're not last minute people, and let them know when I have to get rides for probation. They're not going to help me more past than just making sure that I get rides to my probation.
I just cannot see you successfully completing a 3rd probation after you wouldn't even report on the first 2. You didn't do a single stop. Now it's my turn to talk. You wouldn't do a single thing that you were told to do with your first chance or your second chance. And now
Your
you violated the law. All right, go ahead.
Apologies, Your Honor, but this is, so he was sentenced at the same time on CR 204 and 206. 25 CR 204 and 206, and this was his first revocation on those. And as the court is aware, he does have the city court in which was also revoked. He was sentenced and revoked in the same time frames on that case as well. So this would be his first revocation. I'm not sure if the court was misreading something or what.
Well,
But
I
I
was
just want
waiting
to
for that
clarify
to come up. I thought maybe that was the case. So he was given 2 probations in 2 cases on the same day. So I understand you're making the argument that this is kind of like only his second new case since he was put on probation. And
Yes, Judge, and even the 26 case, it arose while the 25 case was still
Okay.
active while he was in custody there.
While he was on bond, not on probation. Well, those are good points to distinguish, Mr. McClendon. I was contemplating that as a possibility, waiting for that to come up and see if that was the case, if that were the case. And so thank you for pointing that out. That does carry a little distinction. I'm not sure it totally exonerates you, Mr. Simler, that you
I understand
violated
that.
while you were on bond versus probation, because it's still a violation of a court order, a pretty big violation. And being sneaky in the county jail and using somebody else's account so you can have contact with Savannah Height when you're not supposed to.
Your Honor, if I may, I've learned my lesson, and I really don't plan on talking to her ever again, to tell you the God honest truth.
When did you learn your lesson?
Honestly, when I've sat in here and what I went through yesterday and being in here, I don't want to be in here anymore. I want to get my life back on track. I'm just not the kind of person that's meant to be in this jail, especially with what I had to see yesterday and everything like that. And I really just want to get my life back on track, Your Honor.
What did you see yesterday?
Judge, we would like to protect the anonymity of one of the other inmates that had.
Well, all right. Okay, is that the one that we had the emergency situation on?
Yes, ma'am.
All right. Okay, I am aware of that. I didn't intend to ask you anybody's name or give away anybody's private information, but you basically, all right. So yesterday changed your mind, that made you learn your lesson.
Well, that and having to be in jail again, and I finally got my kids back in my life, and I don't want to lose that opportunity. And yes, Your Honor.
Are these children with this Miss Height?
No, absolutely not, Your Honor. They're with totally. I don't have any kids with Miss Height.
All right. How did you get your kids back when you didn't have them apparently before? What do you mean you got your kids back?
I get to have visits with them again. I got in contact with their mothers, and they finally started letting me have visits.
So they're from different mothers. How many of them are there?
3,
How old? What age range?
14 to 5.
And these mothers were not letting you have contact with these children?
Well, not that they weren't letting me. It's just I hadn't had a way to be in contact with them. So I finally got a way to be able to. Finally got a phone with service, and they're going to allow me to start seeing them and everything.
All right. So you violated the court's orders when I told you to report to probation and to do all these other things. You violated the court's orders when I told you on bond not to have contact. The legislature did contemplate the court giving jail sanctions. You've had 31 days in prison. Miss Morgan, has he ever had any other jail sanctions?
No, Your Honor, not on my probations. Like my documentation says, I've never met with Mr. Simler.
Well, I would like to just say I've given you too many chances and I don't think you're going to make it. But the legislature does contemplate jail sanctions. You certainly had one now for 31 days. Both parties are suggesting that I give you the credit of those 31 days as your sanction and return you on probation in all 3 cases. I don't like that. But I do think that the statutes are designed by the legislature to give you a sanction and see if that makes a difference. How many times have you been in jail for other matters prior to this 31-day sanction?
Your Honor, there's only one other time that I was ever in jail, and it was in 2020 or 2019, and it was other than the municipal
long-
case here but other than that, it was only for a couple days.
And Mr. McClendon, remind me, what is that municipal court case? Is that a DV or something of that sort?
Judge, I want to say it was I can't recall what it was, Judge.
Okay, well, that's fair.
um,
I know you've got a lot of cases and you've worked with him a lot. Okay.
Uh,
Did you say he was revoked in that case, or is it still pending, if you remember? Because I sure don't.
that case is resolved, Your Honor.
It is resolved. Okay.
If you recall, we closed
Yes.
that case on
Okay.
Monday.
All right. I didn't recall, but thank you. I thought maybe. All
Your
right, Mr. Simler, you stop talking because you've got me thinking. You don't have me, but the legislature has me thinking that I need to give you this one more probation chance because you haven't had a sanction. But it's a short rope, sir. I'm gonna go ahead. I'm not feeling good about this. My experience tells me your history does not lend itself to probation and you should just serve your sentence. But because the statutes do talk about sanctions, even though these aren't felonies, I am going to give you, as is recommended, credit. I'm going to order a 31-day sanction, giving you credit for the 31 days served. I'm ordering that you immediately, upon release, report to Jessica Morgan, unless she tells me otherwise here, when she wants you to report. And that's in all three cases, all conditions as in the first two. Your probation is extended for 1 year from today and granted for 1 year in the new case. All three 1 year from today. Miss Morgan, would it make more sense maybe to transfer him to community corrections? Would they take him on 3 misdemeanors?
No, Your Honor, he would
right.
have to have a felony
Okay.
case.
All right. Well, Miss Morgan, you're going to be stuck with him for a year, or unless he screws up again and has to come back for revocation. Because I think I do need to give him that sanction. I think that's the intent of the legislature. And I'm not going to make that a precedent. I'm just saying that's what I'm finding in this particular case. When do you want to see him next? As soon as he gets out, or do you want him to make an appointment now?
Your Honor, once he's released, he can come see me at the courthouse on the
Okay.
2nd floor.
And you're here today, right?
Yes, Your Honor.
All right. This is on you, Mr. Simler. You've been given every chance in the book and then some.
Yes, Your Honor. I understand, Your Honor.
Judge, I think we still need to announce his 12 months, underlying 12 months probation on his case. Plus his
Yes.
cost, please.
All right, please let's go back now to that other case, the new case, which is 26 CR 26, if I've got this right. What are your recommendations for sentencing Ms. Gillette in that?
12 months underlying, 12 months probation, court cost, booking fee, probation fee of $60, and court to determine if there's any attorney fees for Mr. McClendon. And I'm not asking for a fine. No contact order with Miss Height remains for the duration of his probation.
All right. Mr. McClendon, you're going along with that, I think you said.
Yes, Your Honor.
Mr. Simler, I'm granting you a 12-month jail sentence that you must serve unless you successfully complete a 12-month reporting probation in the 26 CR 26 and a new probation in the other two cases. 12 months of probation, you must report and do exactly what you're told to do.
Yes, Your
I'm
Honor.
not going to hear any excuses if you come back here.
Yes, Your Honor. I understand.
Oh, I'll listen to them, but you're going to have to do some real serious convincing me to do anything with them. Because I feel like you have exhausted your 3 strikes and then some. No contact with Savannah Height in any way, shape, or form. So I don't know how you're going to get to see these children. Well, you said she's not the mother.
Yes, Your Honor,
Oh.
she's not the mom, and I don't ever want to have anything to do with her again.
Well, that sounds like you're blaming her for being in this position.
No, I'm not. I'm not blaming her one bit at all. I don't have any reason to have any contact with her ever again in my life.
Well, don't have any contact with her. Don't do anything with these other women and the children that will make those children turn out bad in life with being in jail themselves, okay?
Yes, Your Honor, I understand.
If you care about those kids, be a good role model for them. No alcohol, no drugs. I haven't heard much about that with you, if any. So make sure you don't use any alcohol or drugs. That's a standard list of probation that Miss Morgan's going to go over with you. If you ever show up, she'll go over it with you. But if you don't show up, all deals are off. And
That's the first place I'm going, Your Honor.
Okay, you're going to go there every time she says, where are you going to be living in Wichita?
No, Your Honor, in El Dorado, Kansas.
Is that with your mom or your sister?
My sister.
All right.
My mom's the one who's going to have to help because my sister owns 2 different businesses, so she's going to be busy. But my mom's willing to make sure that I can get to probation as well.
Yeah, you keep talking about your sister's businesses. What kind of businesses are you going to be in?
She owns a clothing store, and she also owns a maid service for cleaning law firms and things like that, and apartments for retirees and stuff like that, Your Honor.
All right, so you're going to be helping her with her cleaning service. And what are you going to do for the clothing store, if anything?
Probably going to be a manager, Your Honor.
Are you qualified to that?
Yes, Your Honor. I've been a manager for the last 6, 7 jobs I've had.
All right. Well, I'm expecting this to be your probation, not your sister's, not your mom's, yours.
Yes, Your Honor. I understand.
I'm only giving you this additional chance because the legislature keeps talking about sanctions and so forth. And so I'm going to give you this sanction and see if you mean anything you say, or if you're going to do it, even if you don't mean it. All right. Anything else? Oh, I do. On that new case, you are responsible for court costs, booking fee, supervision fee. I will waive attorney fees because you've been in jail for so long. But you need to make monthly payments on all 3 cases. And I'm going to let your probation officer decide how much you're going to pay each month. Because I don't know what you're going to be making. But your first payment on each case will be due September 21st to 2025 or 2026. And I'm going to expect at least $100 payment on each one, but they can make it more than that if you're able to pay it. If you're living with your sister and she's putting a roof over your head, or your mom, and they're covering your expenses, you should be able to easily pay that on each case. That's $300 a month.
All right, Your Honor.
But probation needs to look at that and see if you can could or should make more. They have discretion.
Your Honor,
Go ahead.
Your Honor, I don't think I'll be able to pay more than that because I also have a garnishment for child support.
So you don't even support your kids. Jeez.
Well, I do. That's why I have a garnish out of all my paychecks.
Well, one of your standard conditions is don't violate any laws. If you don't pay your child support, you're violating the law that says you pay child support. So you need to do everything you're told to do in your domestic case, whether it's just child support or custody and visitation.
Yes, Your Honor. I understand.
All right. Anything further, Miss Gillette, on these cases?
Nope. Did you waive Mr. McClendon's fees?
I did.
Okay.
Mr. McClendon, anything further?
No, Your Honor.
All right. I still expect Mr. McClendon to get paid, just so you know, Mr. Simler, but the taxpayers are going to pick up the court appointment bill. Now, he's working at a reduced rate of what he would if you walked in his door. But you've got to quit putting this burden on the taxpayers of getting in trouble all the time.
I understand, Your Honor.
You gotta get on your own 2 feet and start paying for your own room and board, not the county jail, not the taxpayers, not your mom, not your sister, you do. You need to start paying for your kids.
Yes, Your Honor. I understand, and that's what I want to do. I'm tired of being like this.
All right, well, I'm gonna remember this if I see you come in here on a show cause again, so you make sure you prove me wrong, that you are gonna be successful.
Yes, Your Honor.
Those people want to be proved right. I want you to prove me wrong that you're, because I'm questioning whether you're gonna be successful, but I'm gonna give you this chance.
And Your Honor, I would love to prove you wrong in a good
Do it.
way.
Absolutely, you do it, sir. All right, we're in recess. You're remanded to custody of the sheriff so they can do what they need to get you to Miss Morgan. Thank you all. We are adjourned.
Thank you, Your Honor. Have a great day.
Thank you.
This court next takes up the case of people in the state of Michigan versus Kyler, Kyler Benton. And this is file number 26-14294-H. Appearances from counsel, please.
Nate Carnes on behalf of the people. Attorney Connor Schatz on behalf of Mr. Benton.
We're just waiting. You may all be seated. We're just waiting for Mr. Benton to be brought into the over in Wexford County Jail. All right. Mr. Benton, are you able to see and hear the court? Mr. Benton, are you able to see and hear me? Oh, all right.
Yes, sir.
All right. We are here today for what looks like an arraignment on a bench warrant. This court. This court received yesterday a report from the Community Corrections Program of an alleged violation of his bond for allegedly testing positive to the controlled substance, methamphetamine. Mr. Benton, we're here to tell you, or I'm here to tell you what your rights are. Now, typically when someone fails to comply with a court order, it could be considered contempt, for which the court could give you a conviction, sentence you up to 90 days, and or fines of up to $7,500. However, when it comes to a bond violation, the court tends to treat them as a review of pretrial release conditions. In other words, we review your bond conditions. That's done pursuant to a court rule. So I need to inform you that, again, allegedly you tested positive for the controlled substance methamphetamine yesterday on August 20th of 2022. You have the right to challenge that allegation at a contested hearing and make the prosecutor produce some evidence. Now, this is not proof beyond reasonable doubt, anything like that, but whether or not there are reasonable grounds to believe that you violated the terms or conditions of your bond, which includes not to use or consume any illegal or controlled substance. Now you have the right to be represented at that hearing, question or cross-examine any witnesses presented against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. And of course, you have the right to remain silent and not have that silence used against you. Does he have 2 cases open?
He does, Your Honor. There's a home invasion case that probably doesn't have drug testing ordered in it.
Oh, all right, that makes sense then. All right, well, anyway, if you're found to be in violation of your bond could be continued as previously set by the court. It could be modified, or it could be revoked, and you will be remanded into custody. Now that I've told you what the allegation is, what your rights are, and the possible consequences, I need to see how you wish to respond. I want to turn to Mr. Schatz. Mr. Schatz, have you had the opportunity to speak with him?
I have, Your Honor.
And do you have any idea what he wishes to do?
Our intent is to plead responsible for bond violation.
All right, thank you. Mr. Benton, is that correct?
Yes, and yes.
Please raise your right hand for me. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
All right, you may lower your hand. Mr. Benton, has anybody made any threats, promises, or inducements to get you into violating the condition of bond?
No.
You understand that if you make an admission, we're not going to have necessarily an evidentiary hearing, which might just be the person who tested you coming up here to testify. But you understand that?
Yes, sir.
Is it true yesterday, Mr. Benton, that you had tested positive for methamphetamine at the community corrections office because you had used some methamphetamine.
Yes, sir.
And you knew at the time that that was a violation of your bond conditions in this file?
Yes, sir.
All right, well, the court finds that the testimony today satisfies the relatively low level of burden of proof here, and the defendant is found now to be in violation of his bond for testing positive on August 20th, 2026. Now, I know we also had in past here a show cause that was just about a month ago. That was for alleged failing to appear. Mr. Carnes, your position on what to do with the defendant now?
Your Honor, at this point, I asked the court to impose a remand. However, I had told Mr. Shantz that we would support the release of treatment in this file.
Okay.
But at this time, I think a remand is appropriate.
Okay. Tell me, let me take a look here. What happened on that show cause? It looks like that occurred while I was on vacation.
Your Honor, the court raised that sua sponte, and Mr. Shantz and I talked to you in chambers, and you agreed to dismiss it.
All right. All right. Were there any other bond violations?
No, so that occurred in district. We basically let him off with a warning, told him to show up and test every time. So
I see.
This is the third issue since then.
I see. All right. Thank you very much. All right. We're going to get back to you in just a moment, Mr. Benton. Hold on. Mr. Shantz, before I turn to Mr. Benton, is there anything you think I need to know?
We would just request the bond be continued, and that in the event that it is not, and it is remanded, we will be filing a motion to have him release the treatment.
Okay.
Thank you.
All right. Mr. Benton, something you wish to say, sir?
Yes, I've complied with all orders. I made a mistake. I do agree that I think rehab would be the best thing for me at this point in time. So I would like to see that as I've already set everything up. All I do believe I have to call Dukoski and talk to them to get the papers sent back over, and I will be able to. I can find my own ride. Like I've already set this stuff up. So I know I made a mistake, and I need to deal with it. And I think that's the best way. Best way I think I can deal with it is to go to rehab.
Thank you. Mr. Carnes, I can see here on this felony information, it includes a second habitual felony offender enhancement, but not any second or subsequent drug offender enhancement. You can tell me anything further about the defendant's prior criminal history?
I can, Your Honor.
Thank you.
Uh, 2011, he pled guilty to operating while impaired. In 2012, he pled guilty to attempted breaking and entering with intent. 2013, he pled guilty to misdemeanor retail fraud, third degree. In 2022, he pled no contest to domestic violence and attempted unlawful use of a motor vehicle.
Okay.
In 2025, he pled guilty to disorderly jostling.
All right. I would not expect the probation for disorderly, but was he on probation at the time of this alleged offense back on June 10th? Does anybody know? Mr. Benton, he's shaking his head no. I'll accept that. Was on a probation.
I showed he got 270 days probation on July 25. I guess that there's a good chance that could have been.
Yeah.
I was on from.
Yes,
I was on.
Benton.
I guess successfully discharged.
Yeah, that's fine. All right. Thank you very much for letting me know. Mr. Benton, are you currently employed anywhere?
Currently, no, not again. Because I recently broke my hand, and I couldn't really do much with it.
Thank you. Mr. Shantz, what can you tell me about this potential treatment program? Do you have I know he mentioned Sikorsky Hall. Any other information?
I have limited information. I know we have a social worker that works with our office, and my intent was to have him arrange at a facility that was we commonly use. I don't know all the details, but I will make sure I'm up to date moving forward.
All right. This is only an initial first bond violation. Bond is not to be used as a punishment. It's used to ensure that the defendant is going to appear in court and all court proceedings, but also to ensure his safety and health as well as that of the community. Now, when someone is charged with methamphetamine and then has used and pled to that use, this particular use yesterday can't be used against them to support the other conviction. The court is concerned again with the defendant's health and safety. The court is also concerned that Mission Parole 6.106 allows the court to order rehab and treatment. My concern is that if I release him, not only will he actually follow through, and or if not, will he continue to use? Because in my experience, sometimes people load up, use, and then go to the program. And it only takes a week or so for that to get out of their bloodstream. So what I'm going to do is err on the side of what I think is caution and conservative based upon his own health. The court's going to revoke bond or remand him into custody. And however, Mr. Shantz and Mr. Benton, please hear this. If we're able to get you into a program and get this case resolved, that's a great thing. Generally, I'd like to get get a resolution to the case, because if somebody absconds, that's concerning. So, but if we're able to get this before the court and do a release, resolve it, the court will do so. I want to see him get the treatment that he needs. Mr. Carnes, you look like you wanted to say something.
I actually would just like to speak with you about this case off the record with Mr. Shantz momentarily. That's all.
Okay. Yes, Mr. Benton.
Your Honor, I have never ran from this court ever. Since 2012, I've always turned myself in. I've always showed up for court every single time. There's not been.
Did you turn yourself in on this? No, he would have been arrested yesterday by community corrections. Okay, hold on. All right. Well, counsel wishes to talk to me about something off the record, which I'm more than willing to do. We're going to take just a brief break. Mr. Benton, I'm going to ask that you stay right there. And corrections officers, if you can hear me, please don't pull them out. It should only take us less than 2 or 3 minutes. We'll be in recess in place. You'll join me in chamber. Thank you. Counsel, you can go ahead and one. All righty. So we are back on the record for People versus Benton. I had that brief moment and spoke with counsel in chambers. They just made me aware of some of the background here. The court's going to continue with the remand. And again, I'm fully expecting that Mr. Shantz will come to me very soon, and we can resolve it and have him sent to treatment, because that's what I want to see. And again, I'm concerned for his own health. So, Mr. Shantz, you need to coordinate with, I'm sorry, I looked in at Mr. Benton. Mr. Benton and Mr. Shantz need to communicate with one another, and this court will release him to the treatment program. Just need to know what date, when it's going to go, and we can make.
What if it's tomorrow, Jack? Because I had everything set up.
But it doesn't, I don't care as to the timing. I just need to have Mr. Shantz tell me, yes, he'll go on this date and time to that particular place. Mr. Shantz also knows exactly the form that we generally use for stipulations to allow this to happen. And that's what I'm also seeing from Mr. Carnes. That's what he was telling me. He wants to see you get your treatment. So the answer is let's get off the record so Mr. Shantz can go do what he needs to do to get into that program ASAP. He'll prepare the form, bring it to me, I'll sign it, and we're done. Does that make sense?
Yes, sir.
All right, good. Thank you very much. All right, we are adjourned. Thank you.
Good afternoon. We have a little extra duty today. I've been asked to handle a probation violation arraignment, which we're going to do here in about 5 minutes. All the judges are cross sworn, and I'm sworn to appear as a circuit judge in this matter. All right, we've got everybody we need. There isn't anyone from the clerk apparently going to participate. Good afternoon. This is Judge Middleton appearing by special appearance in a circuit court matter. Title of the matter is People of the State of Michigan versus Reginald Glenn Dwayne Tyler. The circuit court number in this matter is 24, and I'll put a dash in there, 2594 FH. Defendant was originally charged with home invasion in the second degree as a fourth habitual offender. This incident allegedly occurred on October 28th of 2024. The defendant was convicted by plea to a charge of home invasion second degree. Bobby Newland, your probation and parole agent, has filed a probation violation petition. It alleges that you have violated your probation by violation of condition 4.18, which states you must not engage in any assaultive, abusive, threatening, or intimidating behavior. The allegation is that on March 3rd of 2026, you assaulted Juan Tyler, Jujuan, Juan Tyler, by punching him with a closed fist and choking him. Count 2. The defendant has committed the following non-technical violation, which states you must not violate any law of any unit of government, and that you were charged with domestic violence third degree. Count 3 alleges that you must not violate any law of any unit of government. You've been charged with assault and battery. So the first violation is a technical violation, alleging that you violated a condition of no assaultive or threatening behavior. The second two violations, count 2 and count 3, are not technical violations. They're allegations that you've been charged with a new criminal offense. I couldn't find it. I was a little puzzled here. You were placed on probation. Can't tell when from this. And this incident allegedly occurred in March. The warrant was signed in March by Judge Stutzman. It is now August. And here we are. So, Mr. Tyler, how did you come to be in the St. Joseph County Jail?
If you, Your Honor, if you don't mind, before we begin, I have not yet had a chance to talk to him, and I did get correspondence a little bit ago from his agent, Ms. Newland. If you wouldn't mind us having a breakout so I could address that, that would be very helpful.
Yes, it would. Okay, I'll go through the other rights. Bobby, did this incident occur in Berrien County where he lives?
Correct.
All right.
And he's been sentenced in Berrien County to assault.
All right, we'll learn more about that here in a minute. All right, let me open a breakout room where you can speak privately. This gentleman is Mr. Keith Stickley. He is the Chief Public Defender for St. Joseph County, and he made a special effort to be here today at 1:30 to represent your interests.
Thank you, sir.
All right, it should put you automatically in the breakout room. I haven't pressed the issue, but multiple times today, attorneys have shown up without a jacket. So I don't know. I guess that's the new style. I had several this morning. I guess it's sufficient for Zoom. All right. Mr. Tyler, did you receive a written copy of these allegations?
No, I did not.
They didn't serve you with a copy of this at the jail?
No, sir.
Well, I will ensure that you get one. Bobby Joe, this was a home invasion, and I'm not quite always conversant with the circuit court forms. Home invasion second is a 15-year felony. Was he convicted as a habitual?
It looks like he's just been convicted of home invasion, second degree, no subs to it.
The maximum sentence for this matter would be 15 years. Anyway, let's go back to what I was going to ask, or did ask. How did you come to be in the St. Joe County Jail? Were you transferred here from the Berrien County Jail?
Yes, I was transferred here, yes.
Ms. Newland was about to update us. Tell me what the progression is here from charge to conviction to sentence.
So he was initially charged with assault. Let's see. Assault by strangulation, and it was pled down to a assault and battery misdemeanor. And he was sentenced to 93 days with credit for 169 days.
When was that sentence, if you know?
Yes. It was on 8/18/2026.
So sometime between August 18th and now, you were brought to the jail here in Centerville. All right. You have the right to contest this allegation. There's a technical allegation that you have a new conviction in violation. A technical allegation that you engaged in assault or threatening behavior. There's a non-technical allegation that you got a new misdemeanor conviction while you were on this probation. You have a right to challenge that and contest a hearing, a probation violation hearing, where it must be established at least beyond a preponderance that you violated either or both of those conditions of your probation. You're entitled to have an attorney's assistance at this hearing and at all court proceedings. The chief public defender is here with you at this hearing. If we go further, we will either get your original counsel or new counsel to represent you at the hearing. At this point, he's completed his sentence in Berrien County. Ms. Newland, what is your recommendation if the defendant is convicted of first the technical and then the non-technical violation?
Your Honor, I'd recommend that a probation violation report be completed for the courts for sentencing.
All right, so if he pled, you would ask for further pre-sentence report before the court does the sentence.
Correct. His guidelines are 29 to 57 months on this case.
And he received initially a jail sentence and probation.
He received a 30-day jail sentence and a 2-year term of probation supervision.
Oh my. I didn't look at that. The world has certainly changed. Mr. Tyler, you were in somebody's house with someone else who I don't believe's ever been caught. Took the whole rap. cops got there, you're wearing a mask and you got latex gloves on and you got stolen property in your hand. And you got a 30-day sentence. Oh my, I've been away for too long. Your sentencing guidelines are 29 to 57 months to 15 years in prison. So your probation agent's recommendation, if you do plead to this charge, that there be an additional report prepared before any sentence is imposed. And obviously, you would have the right to have counsel at that hearing. So here are your options. You can stand mute, in which case I will enter a not guilty plea on your behalf. You can plead not guilty, in which case I will set this matter for a hearing, hopefully within the next 14 days. You can plead no contest, and I could use the conviction as the factual basis, or you could plead guilty. Mr. Stickley, have you had an opportunity to discuss those options with the defendant?
I have, Your Honor. I've discussed those options and read DOC's recommendation. I understand that the recommendation is that they're willing to dismiss count 2, which would take us, if I'm understanding it correctly, it would only end up in a technical probation with a maximum, I think, of 15 additional days. That being said, because of the sentencing guidelines being a prison recommendation and them already signaling that they would like a probation violation report, I think it's in his best interest, and he would agree, if he stands mute today, we have the court enter a not guilty plea and he'd be assigned counsel. I will tell you, his original counsel is no longer on the contract. It was Lori Hines. So if you could enter that not guilty, and then my office today by the end of business day, if not by about 8:30 tomorrow on Monday, we'll issue a new attorney for him to help him with this, with the rest of the matter.
All right, that sounds like a sound recommendation. If they're gonna ask for prison, why dump the non-technical violation? Seems
Your Honor, I'm not recommending to dump count 3. He has 3 counts. It would just
I
be
apologize.
count 2 for the domestic violence if he wanted to plead to count 1 and count 3. So it'd be pleading guilty to a technical and a non-technical.
Okay.
Your Honor, I misread what it was, that there are in fact 3. That's my fault. I apologize. But the standing doesn't change.
Yes, a technical violation limits the judge's ability to sentence within a certain range, and that would be 15 days. A non-technical violation, like a new criminal violation while you're on this probation, would expose you to resentencing for the violation, and the guidelines would call for a prison sentence. You got a huge gift with a 30-day sentence. Oh, man. You got more time for assault and battery than you got for the original home invasion. Anyway, I'll show you stand mute. Bobby Joe, am I correct? The other person in this never got caught?
I'm not aware if the co-defendant was ever apprehended.
Appoint or direct MIDC to appoint counsel for the defendant. And set a probation violation hearing within 14 days. I also need to address bond, and in this case, bond is denied. You'll be in custody until we can get the probation violation hearing scheduled within the next 2 weeks. All right. I don't know whether I'll be continuing to handle this or it'll be assigned to someone else. I'm not unwilling to continue to handle it, but I'm here just in a limited capacity as other judges were unavailable, and they asked if anybody would do it, and I indicated I would have time to do it. So Mr. Tyler will get counsel to represent you. You can discuss the matter further. They can discuss the matter with the probation department, with the prosecutor's office. This was 2024. This was during Mr. Marvin's tenure before Deborah Davis got here. So I'm not sure what everybody's position is. At any rate, standing mute, I've entered a plea of not guilty on your behalf. We'll get an attorney appointed by the MIDC and set a PV hearing. Yes, you have a question?
I just wanted to know why I'm not able to get a bond on this.
Because you got a 30-day sentence on a 15-year home invasion charge, which shocks my conscience. You got a new criminal charge while you're on this probation. You just spent 169 days in jail. The probation department is going to review this further and decide whether they're going to recommend a sentence within the sentencing guidelines, which would have a minimum of 29 months to 15 years in prison. That's why you're not getting the bond. So thank you, sir. All right. Thank you all. Bobby Joe, Keith, I'm not sure who's going to get this. I'll have to get with Samantha and Jill, see what they want to do, and scheduling when it is depends on who's going to do it. He probably doesn't want me to do it after what I just said to him. So,
Not much of poker face, Your Honor, but we'll get somebody appointed.
we'll get somebody who's got a poker face. I had to cover my face. All right, thank you.
All right, thank you, Your Honor.
Have a good day.
And thank you. As I lean forward in the squeaky chair. Thank you so very much. I have lots of thank yous to say tonight. Dear Lord, when the donation train started, it just spiraled into amazing craziness. Oh, I didn't set up the end screen. You should all document. I apologize. This should all already be done. There it is. The end screen. Look. As if I knew what I was doing all along. As if. Hey, boss. Not like. Ladies and gentlemen, it has been an amazing show. I want to thank everybody for coming out and hanging out with me tonight. I enjoyed this so much. I started things off with the civil case in Thurston because I find those home management cases educational as, I don't know, just all get out when it comes to just knowing what the rules of things are. I mean, granted, that's Washington. We where I live, we don't even have things like basements or sump pump that I know of. That all sounds like very regional requirements, especially with the storm drains and the sewage drains. These are all things that are interesting and new to me. I know nothing about any of that stuff. Mama Wolfie probably knows more about that. She used to be in the whole sewage department thing way back in the day. I got no. But the rest of them were all criminal cases. And we just had one escalating after the other, where Judge Webster, she relented. She gave the guy his fourth chance. And then Judge Elmore gave that guy pretty much another chance that he really didn't probably want to give him, but gave him anyway. Elmore's funny though. He'll tell you when he's forced into the situation. He just don't like it. And then we had the whole situation with Judge Middleton. That was a special appearance among special appearances. I've very rarely seen Judge Middleton shocked by the leniency of an original charge. That was just nuts. And I have to admit, the leniency of that original charge was absolutely crazy. 30 days on a home invasion? How does that even happen? What is that crazy? It's nuts. In addition to all these people on the screen right now, I do want to say a hearty thank you to Miss Good Kitty. She said, let's get the gift thing rolling. She did it hardcore too. Barry Adams came in strong just because we're starting with wastewater and sewage. There's no reason to think it's a crappy weekend, and it's not going to be, ladies and gentlemen. I got a good show set up for tomorrow. Nina, out of the blue, came in just because. Charlene Tutt said this is her way of saying thank you, and I thank you. Thank you so much. And then Miss Good Kitty again comes in because Stickley looks like the Groot from Minions. That's a thing. Groot! I'm your lone wolf Boostle. I'll be back in 13 hours with more court. Be here. Be here for brunch. It's gonna be good. For now, I'm out. That's 11 a.m. Central Time, 12 noon Eastern Time. And remember, only you can take a bite out of crime. Bye! Meow. Killer.